speaker tonight is David Branfman of Branfman Law Group in Oceanside. He's been practicing law for 35 years, and he specializes in new media, intellectual property, and entertainment law. He's a passionate defender of businesses, entrepreneurs, and artists, helping them protect and maximize the value of their intellectual property. He represents and advises all kinds of creatives, from app developers to electronics companies, video producers, nonprofits, apparel companies, restaurants, musicians, authors, and filmmakers, and anyone in between. Sounds like small business. A few of the areas he works in include trademarks and brands, domain names, copyrights and content, licensing, book and magazine publishing, contracts, film, television, video, internet and new media, music, and IP strategies. So, without further delay, MCAI presents one of SoCal's top entertainment attorneys, David P. Branfman.
Thank you, Marilyn. Thank you, everybody. Thanks for all coming out in the beginning of the new year. It's nice to be here. I've been familiar with MCAI for many, many years. Been involved with the San Diego chapter, but now, thanks to Mark, who I've met in San Diego, I have the opportunity to meet you all, and I'm very pleased to be here. Tonight, I've handed everybody a little outline, which is sort of the traditional way. I've done these kinds of things in the past. It's a little more heavy on content, that if we went through that, it would take an hour or two just to kind of go through that material, but I'd like you all to have that. Maybe it'll answer a couple of questions. You can keep it as a resource, but I want to do something a little bit different tonight rather than just sort of go through the outline. And I thought about a slightly different way of doing this, and I'm calling it 12 Top Legal Myths, Independent Film and Video Edition. Because over the years I've discovered there are so many myths out there, and the realities are diametrically opposed to the myths, but the myths are deeply held, and it's a fun way, I think, to touch on some of these subjects. I did not list the myths in the outline that I gave you. If you'd like...
Can I get a couple more?
Sure. If you'd like, shoot me an email at info@branfman.com, and my name is on the front of the outline that I left with you, info@branfman.com, and request the 12 myths, and I'll be sure to send them to you. Now, ironically, right now, I have the 12 myths written down for my presentation tonight. I have the myths, I don't have the realities written down, because I know the realities. I'm happy to talk about them. If you email me, I will send you back the myths and the realities, which will sort of be almost like an outline of tonight's program. And let me just back up a second. Marilyn mentioned that I've been a lawyer for 35 years. I find it hard to believe. But how I got into this was I was a young lawyer here in California. I'd been here a couple of years, and I was doing a little bit of this and a little bit of that, and I was a jack of all trades and a master of none, and I decided that I wanted to specialize in something and get really, really good at something. Particularly if I was going to stay in California and not go back home to New York. And I started looking around for something really that would be of interest to me, something that I would love to do and learn more about. And I started learning about this thing called cable TV, which, if you remember, some of you are of my vintage, and you may recall there was ABC, NBC, CBS, the three national networks, and the local affiliates, and maybe a station you picked up from Tijuana. And that was television. And then this thing called cable TV came along, and they were promising 30 channels of entertainment. And it seemed like, where are they going to get the content from? It seemed like a golden opportunity to start representing independent film and video producers, because where were they going to, these 30 channels were going to need content 24 hours a day, 7 days a week. And that's when I decided I was really going to learn everything I could about this profession and the law in particular. And that was what seems like a long, long time ago and far, far away. And here we are now in 2013. So something I like to do sometimes is ask a question, what I call a gift question. Anybody in the room know who Brian Setzer is, or the Stray Cats? Okay. Anybody know who Dan Hicks and the Hot Licks are?
Yes.
Okay. So I happen to represent, amongst other things, their record label, and I have a special arrangement with them. I have some Brian Setzer CDs and some Dan Hicks CDs, and I'm going to ask a couple of questions during the course of the program tonight, and the first person to answer a question gets their choice of a Dan Hicks or...
Do you have to answer the question correctly?
Yeah, correct. Thank you, Mark, for clarifying. All right. Since we're talking about the golden or the beginning of cable TV, who knows what was the first feature film ever shown on HBO?
God, I should know that.
Okay. Tick tock, tick tock, tick tock. Sometimes a Great Notion, starring Paul Newman, based on a book written by Ken Kesey, was the first film ever shown on HBO.
I thought you were still giving us hints.
Sorry. No, because I want to move the program along since I know everybody wants to get home. And which reminds me, since I'm sort of phrased this in terms of 12 myths, I don't know if we're going to get to all 12 and Q&A, but I'll get to as many as I can. And I will answer any question that I can answer, and if you'd like me to stay a little bit after the program officially ends, I'll be happy to do that, because I know people have gone to the trouble of writing questions. So, I started specializing in cable television or independent television and film production, and I started working for a small law firm, and I noticed that more often than not, even though people were paying me, they were not taking my advice. And I was young and idealistic and frustrated, and I went to my mentor, who was a French patent attorney. He started out as an engineer and became a patent attorney because of his engineering background. And I worked for him for 5 years, and he was a great guy, and I'm very fond of him still, but he had a very thick accent. And I remember going to him and saying, "Henri, I don't understand, why are these people paying me and not taking my advice?" And he said in a very thick accent, which I still do badly, "Well, Dave, as you Americans like to say, you can lead the horse to drink, but you can't make him drunk." And I said, "Henri, I catch your drift. It's not exactly how we say it, but..." So I'm here tonight. I'm going to try to share some ideas with you, myths and realities. You are free to listen or not listen. I will not be offended. Okay. Second question. Now, I've still got all these CDs left. Who got a patent for mounting a video camera on top? What do you want, Brian Setzer or Dan Hicks? Brian Setzer or Dan Hicks?
Your favorite.
Brian, do you like big band? Like 16, okay,
Yeah.
this rocks. Okay, the question was, who got a patent for mounting a video camera on top of a film camera so that he could watch the production in real time and make sure the angles... First video assist.
Because
Jerry Lewis.
He was directing himself, so that's why he came up with it.
Yep. The French are not completely crazy. Back to the French again. Okay. So tonight, as I said, rather than go through the outline, I'm going to try to go through as many of the 12 myths as I can, and we'll try to leave time certainly for Q&A. Now, having been a lawyer for 35 years, one of the things I've learned to do during these presentations is to add what I like to refer to as a weasel-like disclaimer, which is, we're talking in general terms tonight, we're talking about general concepts. None of this is meant as specific legal advice for any one of you that you can rely on in your own personal circumstances. That's not the nature of this, and also I don't want to violate, anybody's confidentiality or anything like that. So we're going to talk in general terms. And please, when you ask questions, if you can, try to make them as, generally applicable to the entire audience as opposed to your particular nuancey situation. It's more entertaining that way. Okay. Myth number 12, and some of these are particular to the film and video business. What do we call it now? Digital media. We probably shouldn't call it video anymore. I'm old school. And some of these are applicable to all small businesses, like myth number 12. Myth number 12. One domain name for my business is enough. If I own one URL, that's all I need. Branfman Law Group, that's the name of my firm, all I need is branfmanlawgroup.com. Not true. Occupy internet real estate. For 10 or 11 bucks a year through GoDaddy or whoever, you can occupy 10, 15, 20 domain names, hyphenated versions of your company name, misspelled versions of your company name, and dare I say, the sucks version of your name. It's very important if you have any kind of profile at all. So I have branfmanlawgroupsucks.com. Why? Not because I'm promoting it, but because I don't want that one disgruntled client who decides one day that the way he or she is going to get back at me is to start a hate website. I don't want them to have that website. And so for a couple of $100s a year, you can occupy 10, 15, 20 domain names, occupy internet real estate, build a moat, if you will, around your core trademark or your core company name, your core domain name, and block some of the unscrupulous competitors out, including, like I said, mistypings or misspellings. You cannot occupy every domain name in the universe. There's too many variations, but pick a budget. I have some clients, they allocate $200 a year. They back out, let's see, at $11 a piece. That means I can have 19 domain names. That's how many domain names they have per year. I have other clients, they have a $1,000 budget for that. And they reverse engineer how many domain names they can buy for $1,000, and that's how many they occupy. It's also not a bad idea if you ever get to the point of being able to sell your business. The buyer of your business will be impressed that you've got this inventory of domain names. It's going to make your business a little more valuable. Okay, myth number 11. Now we start getting into some of the fun stuff, the real fun stuff in copyright world. Copyrights protect content, books, screenplays, treatments, motion pictures, television shows, things like that. Content, not short titles, not patentable inventions, not secrets, content. Myth number 11. I can copyright my idea by sending it to the Writers Guild. Anybody believe that one? Okay, good. Mark, maybe. So the Writers Guild has a treatment and screenplay registration system, which is very nice. It helps identify what date and time you submitted your treatment or your screenplay to them, but it is not a substitute for filing a copyright application with the U.S. Copyright Office in Washington, D.C., which is the only official way of registering your copyright. And it costs a whopping $35 if you do it yourself, and you go to the Copyright Office website, copyright, COPYRIGHT.gov. And in your business, learning how to copyright stuff, learning how to register the copyright in things is your lifeblood. And I recommend that you all learn how to do it. They have an online registration system. They have a lot of free guidelines and manuals and fact sheets. With a little bit of patience and a glass of wine, you can learn how to register your own copyright applications.
You taking questions?
I am, although I want to try to reserve questions to the end so I get through as much of this, and then I'll stick around for all the questions you got. By the way, a related notion to the myth about registering with the Writers Guild is you can register an idea. You can register the copyright in an idea. Not true. Reality, copyright law specifically, by law, in the definition of the law, does not protect ideas. It only protects the way you express the idea, the way you get the idea out of your head and on camera, on a screenplay, in a book, into a drawing, into an illustration. Example. What famous play am I about to describe? Star-crossed teenage lovers from across the wrong side of the tracks fall in love with each other, much to the chagrin of friends and family.
Any one of 12 things but Romeo and Juliet.
Romeo and Juliet, and more recently,
West Side Story.
West Side Story. Same exact concept, same exact idea. West Side Story. Star-crossed teenage lovers from across the wrong side of the tracks fall in love with each other, much to the chagrin of friends and family, leading to tragic consequences. I mean, it's also the basis of God knows how many other hundreds of films and television shows and short stories. If Shakespeare had been alive at the time that West Side Story was first produced on Broadway and then on film, he would not have had a copyright claim against the producers and writers of West Side Story. Why? Because even though the concept is the same, the way the West Side Story producers, writers, and directors created West Side Story, it expresses the theme and the idea in a completely different way. Copyright law does not protect ideas. Next gift question for either a Brian Setzer CD or Dan Hicks and the Hot Licks. Let me finish the question before you answer, Art, because I can almost guarantee you Art's going to know this one. What famous TV show started with this pitch, this four-word pitch? Wagon train in space. Nobody. Gene Roddenberry.
Star Trek.
Star Trek. Now, of course, to understand Wagon Train in Space, you have to know what Wagon Train was. Anybody remember Wagon Train?
Yeah.
Yes.
Right? It was Star Trek, except it was on Earth. Right? But the Wagon Train caravan, for years, wanders around the country. It always puzzled me. Every week they had a guest star, and the next week the guest star wasn't there. What happened to them? What did they do? They got on in St. Louis and off in Santa Fe and never quite made it to California? I don't know. It bothered me. But that was how Gene Roddenberry sold Star Trek, Wagon Train in Space. Now, Gene Roddenberry had a special relationship with the producers of the studio, and he was able, because of his special relationship, to pitch that idea without a screenplay, without a treatment, without anything that was copyrighted, because he had a relationship of trust with the studio, and it was implied from their relationship that if they were going to use that idea, they would compensate him. That is the exception rather than the rule. Do not rely on pitching ideas in the raw and hoping that if somebody uses your idea, you're going to get compensated. Why? Because copyright law does not protect ideas. Oh, yeah, sure. Who answered this? Somebody answered the question with a little prompting.
I had some prompting.
Dan Hicks or Brian Setzer?
Oh, Brian Setzer. Thank you. I saw him on the House of Lords. Thank you.
You're welcome. Okay. By the way, not a gift question, but a fun question nonetheless. What studio did Gene Roddenberry pitch that to? Desi Lu. Desi Arnaz and Lucille Ball's company green-lighted Star Trek. Okay. You're going to amaze your friends and family at your next barbecue. Either that, or you're going to make their eyes start bleeding. Okay. Myth number 10. I don't need to register my work with the Copyright Office all I need to do is mail it to myself. Well, as one reality, not true. As one judge once said, any 7-year-old knows how to steam open an envelope. The only way to register a copyright is to register it with the Copyright Office in Washington, D.C. And by the way, there are some real advantages to going to the trouble of doing that. For example, if you register your copyright and somebody steals your material and you have to sue them in court and you registered your copyright before they infringed your work and you win, they have to pay your attorney's fees, which can make all the difference in the world as to whether or not you can find a lawyer. Because if you have to pay your own attorney's fees with no hope of recovering them, the chances are you're not going to be able to find a lawyer to take your case, and you're probably not going to be able to finance your case. There are other reasons to register the copyright, including in many states, you cannot file a lawsuit for copyright infringement until you've actually registered the copyright with the Copyright Office. It's the key to the courthouse. You can't get into court. Some states like California, Washington, and Oregon have a slightly more liberal rule that at least if you have a copyright application on file with the Copyright Office, not the Writers Guild, forgive me Writers Guild, I don't mean to diss you, but if you have a copyright application on file, at least you can get into court. You have to get your registration certificate, the official registration certificate with the seal, before you go to trial, but at least you can get into court. Register your copyrights. As they used to say in Chicago about voting, you know, vote early and often. Register your copyrights early and often. Okay. Myth number 9. If I want to use somebody else's material, all I have to do is change it 12%. Anybody ever heard that one? No, I've been hearing that one. Marilyn, is it? No, Connie.
Yes.
You've heard that.
That one, yeah, because I deal with writers.
Right,
And
I've heard that.
We've heard 10%.
10%, 12%, 12.5%, 14.25%. You hear all these. There is no formula. There is no formula. The test in copyright infringement is an intentionally loose test. Is the work that's accused of being the infringing work substantially similar to the work that is allegedly infringed? So does work number 2, is work number 2 substantially similar to work number 1? That's a very loose test. There is no percentage. So, some of you may remember there was a hit song, for example, in the early 1960s by a girl group called He's So Fine by the Chiffons. Anybody have a voice? Can anybody sing chorus of He's So Fine?
All these voiceover people here, come on.
Do lang, do lang.
Do lang, do lang.
Yeah.
He's so fine, oh yeah. Okay. Flash forward to about 1970, and much to the chagrin of many of us, the Beatles broke up. Beatle George went out on his own, recorded and released his first album called All Things Must Pass, and the first single from that album was a hit called My Sweet Lord. Anybody remember My Sweet Lord? Okay. The owners of the copyright in He's So Fine sued George for infringing the copyright in the melody of He's So Fine, in My Sweet Lord, and won.
Wow.
Substantially similar. Even though the lyrics were admittedly completely different, and even though the judge acknowledged that George did not intentionally infringe He's So Fine, it was subconscious infringement because of the popularity of He's So Fine, but infringement nonetheless. To this day, if you lined up 100 copyright lawyers and asked them, does My Sweet Lord infringe He's So Fine, I predict about 50 would say yes, and about 50 would say no. Okay. Myth number 8. If I'm doing work for a nonprofit, I can use other people's material without paying for it because my client's a nonprofit. Untrue. Whether or not the entity that you're working for is a for-profit entity or a nonprofit entity is largely irrelevant. Copying is copying. There are a few exceptions for things such as parody, like Saturday Night Live and Mad Magazine, news, research, commentary, critical commentary, but for the most part, copying is copying. Now, example. Let's say I want to do a documentary. Is everybody familiar with the Hotel Del Coronado in San Diego, a famous old hotel? Allegedly modeled, that was allegedly the model for the Emerald City in The Wizard of Oz. Hotel Del Coronado, very famous. Several films, major films have been shot there, including Some Like It Hot with Marilyn Monroe, and one of my favorite films of all time, The Stuntman. Don't know if anybody know The Stuntman. Great film starring Peter O'Toole. You can rent it on wherever. If I want to do a documentary about the history of the Hotel Del Coronado, and I do an hour and a half, 2-hour documentary, and one segment in the documentary I include a bit about films shot at the Hotel Del Coronado, and I show this location and that location, and I incorporate 5 or 10 seconds from Some Like It Hot and 5 or 10 seconds from The Stuntman. That would be considered, in my opinion, a fair use. That would otherwise be copyright infringement, but because it's a very small piece of the feature film and it's for critical or commentary type purposes, I think it would be considered, and it would be considered a fair use, and it would not harm the value of Some Like It Hot and The Stuntman. Compare and contrast to, I'm allegedly doing a documentary about the films that are shot at the Hotel Del Coronado, and I put together a double DVD of Some Like It Hot and The Stuntman together in their entirety, and I call it a documentary about the films shot at the Hotel Del Coronado. Not a fair use. Not going to fly. Okay, myth number 7, related to myth number 8, but a slight variation on the theme. And again, for the people who came in a little while ago, the myths that I'm talking about are not in the outline. I'll be happy to send them to you if you shoot me an email to info@branfman.com. I'll shoot you a list of the 12 fun myths. Number 7, if I'm working for free on a project, I can use other people's material because I'm not getting paid. I hear that one all the time. Not true. Another variation on the theme, myth number 6. If I have a CD or a DVD, if I own a CD or a DVD, I can incorporate portions of it into my project because I own the CD and the DVD. Not true. When you own this DVD or CD, as the case may be, you have the right to give the DVD or the CD away. Your ownership of it gives you the right to give it away. It gives you the right to sell it. It gives you the right to throw it away. It does not give you the right to copy it. So, incorporating what is in your own personal collection into a commercial project is considered copyright infringement. I get this all the time for small film and video productions, corporate videos, annual corporate meetings, all kinds of events like that. This is why God invented needle drops and production music libraries. Okay, myth number 5, except looks like I left it off on my outline. We'll call it 5. Back to trademarks. Trademarks are brand names. Exxon, Kodak, Xerox, Sony, Canon. You know, you look at these cameras there, if you put a little piece of paper on top of the product name, it might be hard to tell whether it's a Sony camera or a Canon camera. But when you see that product name on the camera, you immediately get a feeling, either a good feeling or a bad feeling based on your past experience with that line of products. That's a trademark. That's a brand name. Technicolor, a brand name. Panasonic, Technics, all of these names that you know in your business, those are all trademarks. Okay, next myth. I don't really need to bother registering my company or product name or trademark. All I need to do is put the R inside of the circle next to my name and I am protected. I hear that all the time. I hear it in this variation. My printer told me I should just put the R inside of the circle on my business card and on my letterhead. It's okay, right? As I like to say, I try not to give printing advice. Your printer should not give legal advice. You are only entitled to use that R inside of the circle symbol when your trademark has been officially registered by the United States Patent and Trademark Office in Washington, D.C. Not when you file a trademark application, when 12 to 18 months later the trademark registration actually issues. Question, Art?
But the TM,
TM is okay. The TM trademark you can use the moment you create your product name or your business name. You do not need any government approval. You do not need to have anything on file. You have my permission.
but all it does is it helps put people on notice.
It helps to put people on notice that you consider the possibilities, in Marilyn's case, to be your trademark. You want the world to know that's your brand and they shouldn't copy it. Okay. Next myth. Kind of branching out into corporate matters for a second, because I like to try to cover as many different topics as I can in a short amount of time. Even though I'm in California, I'm better off forming a corporation in Delaware or Nevada because they'll keep my name secret. It may be true that they will keep your name secret, but it really doesn't do you a whole heck of a lot of good if you want to comply with the law, because the law in California is if you're operating in California, even if your corporation is formed in Nevada or Delaware or New York, if you're operating in California, you need to qualify your foreign corporation as a foreign corporation by filling out the appropriate paperwork and filing it with the Secretary of State in Sacramento, which now means you're going to be in their tax system. So it doesn't do you a whole lot of good to incorporate outside of California, in Nevada or Delaware, although there are plenty of people who still do it. I have seen it work in one unique situation. I've represented musical groups who record albums, and what they'll do is they'll form a separate corporation or a separate LLC to run their touring operation as they go around the country. And they'll form that in Nevada or Delaware, and because they don't, because they're always on the road, they don't really have a base of operation in California. And so for that part of their business enterprise, it's legit to form the Nevada or the Delaware corporation. Having said that, I don't give tax advice. If you're thinking about forming a Nevada corporation or a Delaware corporation for your band, how many of you are in a band? Not too many right now. Tell me your name again?
Clarence.
Clarence. Check with your accountant just to make sure it's going to fly. But for the most part, if you're operating in California, you are legally required to notify the state of California and qualify as a foreign corporation. Now, that's the legal requirement, and a lot of what we do is we talk about what the legal requirements are. Often people say, yeah, but if I don't do that, how am I going to get caught? That's a separate issue that I never talk about on camera. No, all kidding aside. I mean, there's the law, and then there's whether or not the law will come into effect, and those are two separate things. But what we try to do is talk about, at least start with what the law is, what you are supposed to do, what you're not supposed to do. All right, now, this is my second to last myth, which always draws firestorm of protest, screams, and sometimes tomatoes directed at me. If I send them 1099 forms, I can treat all of my crew as independent contractors instead of employees. I do not work for the Internal Revenue Service. I do not work for the Employment Development Department of the state of California. I never have and probably never will. I'm simply here to share with you what I've learned, what some clients of mine have learned the hard way. The state of California and the Internal Revenue Service frown on independent contractors. In their world, you know how we're all supposed to be innocent until we're proven guilty? As far as the IRS is concerned and the Employment Development Department is concerned, you're all guilty until you prove yourself innocent if you're trying to treat your crew as independent contractors. In fact, if you are interested in learning more about this, at the back of my handout is a form from the Internal Revenue Service that I copied for you called an SS8 form. And this is a questionnaire that the Internal Revenue Service uses when questions come up about whether somebody is an independent contractor or an employee. And you can see if you add up all the questions in the subparts, they have about 45 different factors that they use to determine whether or not somebody is an independent contractor or an employee. Now, for example, I have my own law firm, I have my own office, I have my own professional corporation, I have 3 people who work for me, I have my own insurance, I have several dozen clients. As between me and my clients, I am clearly an independent contractor. However, one day, should one of my clients grow big enough where they would like me to stop doing what I'm doing for everybody else and kind of just move my desk over to their office and use their computers, and they'll provide me with some secretarial, and I pretty much do their work most of the time. I've now shifted from independent contractor to employee. How does this come up? This comes up if you're the producer and you hire somebody on your crew and they get hurt on the gig. And they go down to the Employment Development Department and they file a disability claim, and you as the hiring party are not in the system as an employer. Now you're on their radar screen. They file either a disability claim or a workers' comp claim and you haven't been paying workers' comp. You're not in the system. Now you're going to get a phone call, a visit, or a letter from the EDD. Scenario number 2, you've got somebody on your crew, you've had them for a while, and then something happens. They fall on their head and they're just no longer doing the job, and you want to kind of go your separate ways, and you sort of say in a nice or not so nice way, you know what, Charlie or Sally, don't show up on Monday. Don't need you anymore. Things aren't working out, or however you might say it. In other words, you sort of separate them. And they go down and they file unemployment benefits because they think you're their employer. And you're not in the system, and now the EDD wants to know why you haven't been paying the employer's share of the payroll taxes. How can you, how can you try to avoid having these problems and still treat people as independent contractors? It's doable, but with some difficulty. For example, you'd want to have a written agreement that clearly states that they're an independent contractor. You'd like to know and have them prove to you that they have their own liability insurance. You'd like to know that they have a business license. You'd like to know that they have, did I say insurance? Did I mention insurance? Yeah, insurance. They have a business license. Ideally, it would be great if they were an LLC or a corporation. And they have to invoice you, as opposed to you just issuing them paychecks. It's kind of like, try to think of it like, have you ever hired a painter to come to the house? They show up with their truck, their ladder, the paint brushes, the drop cloths, all the tools they need to do the job. And by the way, they pretty much tell you when they're going to show up, and you better be there or else you won't see them for a couple of weeks. That's an independent contractor. As close as you can get to that in the film and video production world or media world, the higher the likelihood is you're going to be able to sustain the argument that they are independent contractors. The problem, of course, is they can't show up when they want to show up. You have to tell them where, not only when to show up, but where to show up. That is one of the factors that the IRS and the EDD are going to use to determine whether or not they're an independent contractor or an employee. Why not treat everybody as employees? That's the safer way to do it. It adds about 15% to the cost of having that person work for you. And you just have to decide what your threshold for risk is. Do you want to take the risk or not? Is it worth adding on 15% and either making 15% less or having to add 15% to the cost of the job to your client or your customer, or splitting the difference or something like that? We all take risks. We all get up every day. We get in our car. The minute we get in our car and get on the highway or get on the surface street, we're taking a risk. We try to mitigate those risks. We try to limit those risks by driving with our eyes open and not drunk or otherwise under the influence of any other substances, right? That's how we minimize our risk. We keep our eyes open, we look around, we try to be smart, but we're taking a risk. Same thing with independent contractors and employees. There's a cost-benefit analysis and a risk analysis that you have to go through. Okay. And the number one myth of the last 10 years, and then I'll be happy to open it to Q&A, and I got some on the cards. Anybody want to guess what the number one myth is? The number one myth, and I don't care whether it's the film and the video business or the clothing business or the non-profit, I don't care what business it is. The number one myth of the last 10 to 15 years is, if I can find it on the internet and I can figure out how to download it or use it, it must be mine for free. I don't have to pay anybody because it's on the internet. And either it is for free or it should be for free. There's that sort of political question. Short answer, not true. Just because you can find it on the internet doesn't mean it's free for you to use it. No more than it's free for you to incorporate the sounds or images on the CD or the DVD in your personal collection. Chances are that material that you find on the internet is owned by somebody else. Either the photograph or the right of publicity or the music or something. And to minimize your risk, what you would want to do is go to, let's say, a stock photo library or some other licensing agency and get permission in writing to use that pre-existing material. Again, to reduce your risk. In the last year or two, I've seen, I think, close to a dozen cases of people who don't exactly remember how the picture of that dog got on their website, or the picture of those flowers got on their landscaping website, or the picture of that sunset got on their website, but now they've received a very nasty letter from Getty Images or Masterfile or Corbis saying, we represent the owner of that image, we're their exclusive licensing agency, we've discovered that you're using this image that we have the licensing rights to on your website, pay us $15,000 or we're going to take you to court and sue you in federal court for copyright infringement. I've seen about a dozen of those. Anybody had one of those or heard about one of those?
Yeah, and Getty crawls. I had hired someone to my website, and he said he didn't understand the photo. Anyway, he had used a photo that he said that he had paid for it, he hadn't. And Getty has web crawlers.
Oh, sure.
Find it. And we settled it. I mean, obviously we settled it, yeah.
God bless the internet. They can now with digital imaging and crawlers, they spend all day every day
just sent a screen grab with the bill.
Right. All right.
I heard last night Chrome now has a little extension that will actually check all your photos.
There you go.
And tell you whether or not somebody else has the rights to it.
I would verify if that is accurate, but that could be a great service. Right. All right. So that's Dave Branfman's 12 myths for, but there might have only been 11, if I miscounted.
Letterman only has 10.
That's right. I was trying to do.
Wow, what a bonus.
I was trying to keep it to 10, but I couldn't help myself. I got 3 questions on cards, so why don't I go with those, and there's more even, and we'll go from there. Wowie zowie. What time is it, Mark?
8:12, but we didn't start with you until, who knows what time, it's like 7:30, almost 20. What time do we need to wrap up, John?
At 9 o'clock,
Okay.
at the latest.
Because I got 10 questions so far. So we'll go until the gong rings. Okay? And I'm taking these in no particular order. What type of issues do you find that litigation is required and are most settled out of court? I would say litigation is required when you've exhausted all other opportunities and efforts at resolving your dispute. When you've tried talking to the person. When you've tried getting a neutral third party who you both trust and both like, maybe to sit down and try to do an informal mediation for you. If you've gone to formal mediation, where you've actually hired a professional mediator to try to get the matter resolved for you, and you still can't get it resolved, and you really feel strongly about it, that's when litigation going to court is the last road to go. Let me say this about court. Most cases are ultimately settled before they go to trial. I would say more often than not, let's say there's 2 parties in a lawsuit. Sometimes there's 3, sometimes there's 5, sometimes there's 10, sometimes there's 20. But let's say there's person A versus person B, and person A has a lawyer and person B has a lawyer. At the end of the day, who do you think are the most happy people in that room? Person A, person B, or the 2 lawyers? 2 lawyers. Is that a good use of your time and energy and money? No. Sometimes you have to. Don't forget, of course, there's small claims court, which I believe, as of January 1, on some cases, the limits, I'm not an expert on small claims court, but you can Google small claims court California and find a lot of the rules. I believe on some cases the limit is now $10,000, which makes small claims court not so small anymore. Maybe $7,500, but small claims court is a good tool to learn how to use if you have to. Having said that, I recently had a case where a client of mine was owed about $15,000. We couldn't go to small claims court because it was over the small claims court limit. We had to go to Superior Court. It meant a lot to my client. I tried to talk the client out of it because the client's been a long-time client, and I wanted him to be a long-time client. I wanted him to continue to be a long-time client. I didn't want to go down this road and have him be mad at me at the end when what I predicted would happen, which is we settled the case for about $12,000. Which is not bad. I mean, he got almost 75% of what he's owed, but guess what it cost him? About $8,000. Litigation is the last resort. Okay, moving on. Two questions regarding, I thought it said burgers at first, and I didn't quite get it, but who's Laura? Laura, work on your penmanship. Sorry. No. It's 2 questions rate bloggers.
That's legal advice.
Yeah. 2 questions rate bloggers, not burgers. Okay. What's the liability, if any, for someone if someone is injured after taking advice from a blog? I'm not sure. That's a sort of an open-ended question. What kind of advice? Is the advice, hey, I Laura, recommend that you go find the highest building that you can find and put on a pair of butterfly wings and jump off the top. I think you'll have a good time. You might be liable for that, Laura.
I was thinking in the realm of, say, dietary or health advice.
Well, I'm not sure I have a completely accurate answer to that, but I would say that there are a couple of ways to limit your risk. One is to put a disclaimer on there that this is sort of general advice based on commonly accepted or common, research that you've done, but each person should consult with their own physician or nutritionist before embarking on any kind of health, nutrition, or exercise program. And then number two, if you can, again, in terms of minimizing risk, see if you can buy insurance, blogger insurance. There's probably an insurance company out there that will write blogger insurance or something like it. And it might be worth it, again, to minimize your risk. Okay. Related question from Laura. Are defamation laws as strict for bloggers? In other words, are blogs considered free speech? I don't think bloggers have any greater or lesser liability or responsibility than any other journalist, writer, newscaster, or broadcaster. Defamation is defamation. Libel, if it's in writing, slander, if it's oral, those are both the two categories of defamation. Remember that defamation by a public figure, or a public figure trying to bring a defamation case, has a much harder hurdle, a much higher hurdle to overcome than a private figure. In other words, if you're a public figure, the chances of you being successfully defamed are much higher. On the other hand, if you're a private figure and somebody says something about you which is demonstrably false and spurious, such as, I believe Chef Andre at the restaurant down the street routinely poisons his customers, that's not an opinion. That's a false statement of fact. And assuming Chef Andre is not a public figure, he may have a good claim for defamation against you. Accusing someone of having a sexually transmitted disease when that is untrue is probably defamation. But blogging is not necessarily automatic safe harbor free speech.
I have a quick question
Connie.
regarding the opinion. How about if you put in there, it is of my opinion that his food tastes like he's poisoning. Does that...
I'm not sure that is really going to cover the fact that you've made a false, what he would argue is a false statement. Now, having said that, and I don't want to get too far down the road of defamation, California and some other states have a law called anti-SLAPP, an anti-SLAPP, S-L-A-P-P statute. SLAPP stands for Strategic Litigation Against Public Participation. And the anti-SLAPP statute says that if you are writing something about that is a matter of public interest, and the person you're writing it about tries to sue you to stop you, you can bring a special motion in front of the court to have the case thrown out. This makes defamation cases in California much, much harder for the plaintiff, the person who has allegedly been defamed. It makes it much harder for those cases to bring. So between the fact that the person, if you've written something that's allegedly defamatory, beside the fact that you are going to couch it as an opinion, beside the fact that they're probably a public figure or maybe a public figure, now you've got this anti-SLAPP statute, which is going to give you a real leg up to allow you to go into court and ask the judge in the first 30, 60, or 90 days to throw the case out. And by the way, if you win, if the judge agrees that the case violates the anti-SLAPP statute and the case should be thrown out, the court must award you your attorney's fees. So the allegedly defamed person must pay your attorney's fees, assuming they have the ability to pay it, of course. This makes defamation in California much harder to bring, and I have pretty much stopped pursuing defamation cases on behalf of plaintiffs in California. They're just too difficult. That's not to say there aren't lawyers out there who are willing to fight the fight, but they are much tougher than they've ever been before, which is good news if you're in the business of defaming people. I say that facetiously. Okay. How do I know when I need written permission to use an image or video or audio? Well, we kind of talked about that in the context of myth number one, which is if I can find it on the internet, it must be for free. If you're using somebody else's material, chances are you should ask for permission. Now, there's lots of theories about this that we lawyers bandy about. One of the theories is it's easier to ask for forgiveness than permission. In other words, if you ask for permission, you're never going to get it. Or you're going to get it, but the price is going to be too high. And it's easier to just go ahead and do what you're going to do, and if somebody comes after you, you say you're sorry and say you'll never do it again, and you'll pay a nominal fee. Often that will resolve the problem, not all the time. I recommend using a version of the golden rule. The golden rule is do unto others, right, as you would have them do unto you. My version of that is don't steal from anybody else any more than you'd be unhappy if they stole from you. In other words, put the shoe on the other foot. When you're thinking about using somebody else's material and not getting permission, ask yourself, hey, if this was my material and they used these 5 paragraphs or they used these 3 photographs, would I be calling up a lawyer saying, please do something about this? Now, there's lots of nuances to permissions, and in fact, there's an entire book about permissions. Is everybody familiar with Nolo Press, N-O-L-O? Yeah. Nolo Press is a wonderful little company based in Northern California. They publish all kinds of do-it-yourself legal guides. They're pretty good. I recommend them. Certainly to get a heads up and to learn more about any of this kind of stuff, and they have a book on permissions. And I think any of you who are in the business of using other people's material or want to use other people's material, I recommend this book. We could spend 2 hours just talking about permission. When you need it, when you don't need it, what you can do, what you can't do, what's in the public domain, what's not in the public domain. It's a dicey area. Okay. Related question. We copy articles from the web, newsletters and such, to use on our website and always give them credit. Is it okay? They did not sign their name to this. Good for you. No, it's not okay. I mean, you're using somebody else's material. The fact that you give them credit, attribution, is not the same as permission. If that were true, all I'd have to do is start copying songs from any of these albums and say, hey, courtesy of Dan Hicks and the Hot Licks and Surf Dog Records, and I'd be in the clear. That doesn't do it. Okay. Wow. Okay. If I have, next question. If I have a client who wants me to use copyrighted material in their video, am I liable? Well, you're in the firing line. You're going to get named in the lawsuit, or you're going to get the letter if the person whose material that your client wants you to use gets mad about it, because you're the business and you should know better, and you're the deep pocket, or at least appear to be the deep pocket, you're going to get embroiled in this. Again, insurance could cover you. Certainly, producers' liability insurance should cover this kind of thing. The other thing you can do, if your client is going to be around when the problem arises, and if your client has a couple of nickels to rub together, is in your agreement with your client, you make sure that there's a provision in there that says, if you, client, ask me to incorporate material that belongs to a third party, you do so at your own risk. I disclaim all liability and all responsibility, and if I get sued or threaten to be sued, you will indemnify me and hold me harmless, and you will pay all my legal fees and you'll pay all damages. It's not my problem. That is good as long as when the problem arises, your client can be found and your client has two nickels to rub together. If your client can't be found and your client doesn't have two nickels to rub together, that indemnification in your agreement with your client is not going to get you off the hook as far as the person whose material you incorporated is concerned. You would say, hey, look, I have this agreement with my client. They said they're responsible. And the person whose material you used is going to say, great, you go after them. Not my problem, your problem. So that's why I say that provision is only as good as your ability to find the person and their ability to step up, which is why at the end of the day I keep coming back to insurance. I do not sell insurance. I have never sold insurance, and I hope never to sell insurance. No disrespect to any insurance agents or wannabe insurance agents in the room.
But you refer to producer's liability insurance. I'm familiar with general liability insurance, but you're...
I think you can get, I mean, I would not want to rely on general liability insurance blindly. I would want to make sure that the general liability insurance doesn't have an exclusion in the fine print if you're in the business of commercially producing media, which is why you might need to get a rider if you're in the business, or get a policy that's specifically written for producers of digital content or recorded content. For example, I have a client that's a Jimbo production company, they got sued, or they've been threatened. They have not been sued. They've been threatened with a lawsuit for copyright infringement. Much to my amazement and joy, they had purchased about a year before insurance coverage for just this kind of eventuality, because it's only a matter of time before your number comes up. You know, you're in the business, you're in the content business. Sooner or later, something's going to come up. You had the website problem. We've all heard about problems. So I think insurance, if you're serious about it, insurance is a cost of doing business. Okay. Topic. Poor man's copyright question. So, are you saying that the poor man's copyright was never recognized? By poor man's copyright, do you mean mailing it to yourself in an envelope?
Right, because I used to do that.
Yeah. Let's say this. I've been doing this since 1979. So that's almost 34 years. It hasn't been recognized in the 34 years that I've been doing this. It is an urban legend.
It's just nothing nothing ever came up behind it.
Well, you never had to sue anybody, and you never had to prove that you had a copyright.
Exactly.
Good for you. You're a lucky man. You must help little old ladies across the street, or something. Okay.
They're not under his car.
We keep going. Bring them on. Number one, these are two related questions. I have liability insurance for production, but I'm not clear about my hired independent contractors being injured. Generally, am I responsible even though they are independent? Okay. And the second question is not exactly, well, Were you here, whoever wrote this question, were you here for the discussion about the SS8 form on the back of?
I wrote that question before you got to the SAT.
Oh, okay.
So.
Tough question. Tough question. What you can do, if you've got the intestinal fortitude, is you go through the SS8 form, read the 45 or 50 questions, and they pretty much tell you what you need to do. Because you can see by what they're looking for, what they are going to consider to be the indication that somebody is an employee, not an independent contractor. Related question, or question number 2, how do I protect my idea when pitching to producers, reps, etc.? Well, first, and this is going to sound naive, don't pitch to anybody you don't trust. Okay, by the way, we'll all appreciate this. You know, has anybody ever said to you when presented them with a contract and they said, I'm sorry, I don't sign contracts. I don't need to sign contracts. My word is my bond.
Run.
Run. Why? Because the subtitle of the movie is, I intend to screw you. At least in my experience. And believe it or not, I'm not that much of a cynic, but I'm a cynic when it comes to those things. Mark, I think, you know, it's very tough, especially if you're at one of these pitch fests. Those are open season. Now, what I sometimes do is I'll put the pitch in a sealed envelope and I'll write a cover letter and I'll say, hey, enclosed please find a wonderful idea that I think you're going to love. I'd love you to read it, but do me a favor, let's do this, you know, let's understand that I'm disclosing this to you with the idea that if you use it, we're going to work a deal out and I'm going to be compensated. If that's not okay with you, send it back sight unseen, I'll understand. Now, they open it up, you've got an implied agreement, even though they haven't signed anything. Hard to do, not likely to succeed in too many cases, but this is very, very tough. Art?
I think that's the reason why the vast majority of legitimate firms will not accept a pitch
Yes.
that way. They want it to an agent, somebody
That's right.
they trust and have a relationship
That's
with.
right. So that's another way of doing it, is you have to go through an agent or a lawyer who has the relationship. But virtually every hit film generates a lawsuit that they stole my idea. By the way, I didn't bring it with me. If we do this again next year or something like that, which I'd love to do, I will bring you an analysis of Star Trek and the Wizard of Oz. There's an argument to be made that the Star Trek is a copy of the Wizard of Oz when you start seeing the 25 elements lined up side by side. It's rather fascinating.
Just put some lunch, please.
I wish I had a better answer, Mark. Sure. It's tough. Okay. What's the value of common copyright without notice and filing for copyright in Washington, D.C.? Well, I think we kind of answered this. The value of the common copyright, which there is really no such thing anymore. There's no such thing anymore as a common law copyright. What there is the copyright comes into existence at the moment of creation. So you get that idea out of your head onto paper, either in the form of a treatment or a screenplay or a manuscript or a drawing or an illustration or a sculpture. You've now taken that idea and you've expressed it in a tangible form. The copyright comes into existence. You are not required by law to register the copyright. There is a copyright. However, one minor technicality. As I said earlier, you can't sue somebody for copyright infringement until you've registered the copyright in Washington, D.C. So you have a copyright. And now what you have to do before you go racing off to the courthouse is you have to go file the copyright application. I've had this happen. I had this happen recently. A client of mine created a work of art years ago, never bothered to register the copyright. He did put the C inside of the circle, as I did on the bottom of my outline. You see the copyright notice? He did put the C inside of the circle and the year and his name on his website and on the instructional materials. He's a wood carver. And, but he never registered the copyright, and lo and behold, somebody ripped them off. We had to go racing off to the courthouse, register the copyright on an expedited basis, pay a few extra $100 before we could go file the lawsuit. And we talked about the value of registering the copyright. You need it in order to file a lawsuit. If you register the copyright before the infringement takes place and you win, the other side has to pay your attorney's fees on top of any damages they might owe you. And there's some other reasons that I won't bore you with right now about why it's really worth registering the copyright. And in the whole world of things you can register, copyrights and trademarks and patents, copyright is the most economical. $35. You can't beat it. You just can't. Okay. Hey, we're almost getting to, oh no we're not. We're almost getting to the end. All right. Interesting question. Does case law set precedents, or do contracts with correctly worded terms govern over many disputes? It's a combination of both. It's what the contract says and what the law says. So if you have a contract that violates the law, then the law is going to supersede. For example, there are certain things that a landlord or property owner is not allowed to put in a lease if they rent out an apartment or a house. Or they're unenforceable if they are in the lease. So they're in the contract, but they can't be enforced in a court of law. So even though it's in the contract, even though it's plainly written, even though it's plainly worded, it is not going to be enforced in a court of law. So what the law is really a combination of contracts, if there's a contract, the law as it's set forth in various statutes, and cases, as cases and judicial opinions have been handed down over the years that set legal precedent. There's also the factor of what the judge says it is, or what the jury says it is. But ultimately, if the judge or the jury makes a bad decision, that's why we have the appeals process that sometimes ultimately goes up to the United States Supreme Court. All right, we're still rolling until somebody gongs me. I got 6 more to go, 6 or 7. Okay. I can't read the first word. At what point should you apply for an LLC, and what's the reason to get one? Good question. So an LLC is a limited liability company. A limited liability company is only one form of business entity that you can form. Another is a corporation. Another is a limited partnership. Another is a general partnership. These are all different entities. By the way, Nolo Press has a book on corporate entities and other formations. That's another 2-hour subject. I would say you want to form an entity of some kind, a corporation or an LLC, when you start having personal assets, whether it's money in the bank, cars, video equipment, bank accounts, savings accounts, 401ks, things that you would like to protect from being attached if something goes wrong in your business. That's a good time to form a corporation or an LLC. Another good time to form a corporation or an LLC is if you have a tax professional like an accountant say, it's time for you to form a corporation or an LLC. I'll give you an example. For many, many years, I operated as a sole proprietor, not as a corporation or as an LLC. And I found that everybody got paid before me. All the bills got paid before I ever got paid. And every once in a while, if things looked good, I would write a check to myself and feel good about it. And then about 5 or 10 years ago, the accountant said, Dave, you're an idiot. Form a corporation, get on the payroll, you need to start treating yourself like a human being, and you need to get a paycheck every 2 weeks like everybody else. And life has gotten better since then. It's more expensive, it's more of a headache, there's more paperwork, there's accountants, but for me, it has worked out. I'd say, by and large, it's been worth it. And where you really want to do it is when you really start having personal assets that you want to protect. Now, of all the things that you can do, sole proprietorship, partnership, LLC, corporation, I would say the last thing you want to do, the thing you want to avoid the most at all costs, is an old-fashioned general partnership. Because now you and all of your personal assets are on the line for any mistake that your idiot partner makes. Better off having then you really need a corp. If there's 2 or more of you, I think you really want to have an LLC or a corporation, and you got to maintain it right. Do everything you're supposed to do. Hold your meeting once a year, the shareholders and the board of directors if you have a corporation, the members if you're an LLC. Really treat that entity as a separate business entity, separate from yourself, to try to protect yourself from claims made by unreasonable clients and idiot partners. Okay. Model releases for minors. Yeah, another dicey area. You get the parent, first of all, if they're a minor, you want to have a release signed by somebody. Of course, the interesting question is, if the father signs it and the mother has custody, oops, maybe the release signed by the father isn't good enough. And you don't know. So, in a perfect world, have both parents sign the release. But anybody besides me think it's a perfect world out there? At least having one of the parents sign the release gives you some arguable basis for arguing that you thought you were doing the right thing, and you had a parent who appeared to be the responsible parent sign the release, and therefore you should not be held accountable. But what's the backup? And the word begins with an I.
Insurance.
Dan Hicks or
Stray cat.
Stray Cats?
Thank you.
It's Brian Setzer, but okay. By the way, best live big band I've seen in the last 10 years. If you ever get a chance to see Brian Setzer with his big band, it'll blow your socks off. Okay. Oh,
Brian,
that's interesting. Somebody actually...
Brian Setzer.
Yeah. Whoever wrote this question actually saw my issue about custody. Do custody arrangements impact what parent can sign for minors, and how does an... I don't know the answer to that one. If anybody out there has the answer, send it to me. I'd love to know if there's a great answer to the question of what if one of 2 parents signs and it turns out the parent doesn't have actual custody of the minor.
Could be Charlie Sheen.
Yeah. Could be Charlie Sheen on a bad day.
I was just gonna say both parents ripped off Gary Coleman.
Gary Coleman? Jerry Coleman used to manage the Padres. I don't think you mean him.
No, Gary Coleman, the actor.
Yeah.
Different strokes.
I thought he said Jerry.
Both of his parents ripped them off.
Is that right?
Yeah.
Sad but true. It happens every once in a while.
Who the dad on that show just died today?
Collaborations in music videos. What's the standard, what's my experience, is the standard way for videographers and music artists when putting together the music video, who owns the finished content, what's the industry standard? That's a question we could spend an hour on. So, I mean, again, I think you need to have a contract, and you need to talk about these questions ahead of time. And everybody needs to kind of get their expectations out on the table and try to arrive at something that you can both live with. I mean, typically, the person who wrote the words and the music owns the song. The band or the record label, the musicians, pardon me, or the record label, if there's a record label, own the sound recording, the way that song is put on disc. Now, you're the video producer, you own the video. Well, you may have ownership in the video because it's your blood, sweat, and tears that has created the visual elements, but it's unlikely that you would end up with ownership of either the words or the music or the sound recording. Now, I think the question suggests, correct me if I'm wrong, that you as the producer of the music video are working on spec. You're not being paid a fee to produce the music video. Obviously, if you're being paid a fee to produce the music video, they're going to end up owning the visual elements. That's the standard. I presume the question is, what if I am not, I'm not being paid a fee, but I'm working on spec?
Yes.
You need to have an agreement with them that says how you're going to be paid, when you're going to be paid, and what you're going to be paid from, and how often. And you want to have in that an agreement that you're going to be paid, you know, every month, every other month, once a quarter, twice a year, and you have the right to inspect and audit the books. And exactly how you're going to be paid and from what revenue stream. By the way, my theory is once a month, once every other month minimum, so that you, on a regular basis, you're getting feedback as to whether or not these are honest people that you're doing business with. If you leave it to once a year, you got to let a whole 12 months go by, then you don't get anything. Now you got to chase them down. Now another month or two goes by, and you're in month 14 before you find out you're nowhere without a paddle. Whereas if they have monthly or bi-monthly accounting duties to you, you're going to know a lot sooner. And by the way, if you're doing it on spec, you have the right to expect monthly or bi-monthly payments, I think. Does that help?
Yeah.
Okay. Art, you had a question or a comment?
I do.
Yes, ma'am.
I'm going to try to do this real quick. I am in a position where I do that. I have a contract. Anytime I do any work with anybody, I have them sign, you know, specifically what it is that I'm going to be providing, what the agreed price is that we agreed, that what my charges are, and that I'm entitled to a digital copy.
Yes.
That I can use on my website.
Yes, right.
Okay.
Good, good, good.
So there's a number of things in that contract, and in the very beginning I didn't do it, and then after just talking I found out, ooh, you better be doing that for every single
Right.
job. So I did, but the one thing that's always bothered me is my client is the production company. We engage together on the talent, he's the production company.
Right.
His client is the one that he's doing the video
Right.
for. So for me, my contract's just with him.
Right.
And he is engaged in this contract, yes, I will give you a digital copy. I'm just wondering, is there something more I should be doing, making sure that your client is agreeing that I can have this copy?
Well,
Because I am part of the collaborative work.
in the length of time that you've done this, has the ultimate client ever objected to your? No. And I think you're, you know, you're
I
in.
probably overthink it, right?
Yeah. Well, I mean, I suppose.
I just want to protect myself.
I suppose if you want to reduce the risk as low as possible, you could ask the production company to get something in writing or from the ultimate client that confirms that yes, they understand that you have the right to a digital copy for your website so that you can stick it in your archives.
Right.
That would be, again, reducing risk.
Right.
Connie?
I have had a couple of clients who you ask for a digital copy and they'll say they'll get you something, but they never do. I've got one that's for years I've been contacting her, and she's the person I worked through. I got the job through her. And she keeps saying, oh yeah, I'll contact them again, but they never send anything. And then I had one that actually sent me something, but they sent me it 3 years later.
Right. Well, what if you did this? I'm just brainstorming with you. What if you put in there, you will send me a digital copy within X days, 10, 20, 30, 50 days, 60 days after completion of the project, and if you fail to do so, I'm entitled to an additional, pick a number, $100, $500, $750, because part of my deal with you, part of the price that I gave you is based on the fact that I'm getting a digital copy that I can use on my website. That credit is worth money to me. If you're not going to do that, then I'm entitled to additional money. Now, if you don't get the digital copy and you ask for the money and they don't pay you, you're left with going to small claims court, but at least you got something, and what it does is it puts a value on that, and who of us don't think that credit is worth money? I mean, we know that credit is worth money.
Future business.
Yeah.
Truly.
So, and I think you could put a value on that. And I'm just brainstorming with you, but if that's in the contract, I think you could, it would be enforceable, and you could even state it, you know, the price is X dollars. However, if you provide me with a digital copy within X days, I will reduce the price by,
I like that.
That's more of a positive thing.
it's more of a positive thing.
Incentive to want to
Instead of a penalty,
Right.
it's an incentive. Just a thought. Okay, we're almost down. If you accept video clips from others, how important is to follow up on if they've received permission for photos, music, etc., or is it their responsibility? So the question is, how important is it? Let's see.
What's that mean?
I'm like, huh?
You can, again, you can have something in your agreement with them that says it's their responsibility, and if you get in trouble, they're going to pick up the costs and defend you and all that, but that's only as good as your ability to find them and their ability to back it up. Again, the backup is insurance. All right, last question. Proving once again that this really is 2013 and not 1993. Pinterest. If a violator pins an image on Pinterest without permission to use it, does he or she become responsible for repins of that image? I don't know the answer to that question off the top of my head. Pinterest is relatively new. The law is still developing. They're changing, just like Facebook, they like to change the terms and conditions on you on a regular basis. Their position is they're just a bulletin board and it's not their problem, it's always somebody else's problem.
I'm sorry, I didn't mean Pinterest, I meant the violator. In other words, let's say a client of yours pins your image that you had made. In other words, they launch it into Pinterest, and when I then file a claim against them, can I actually have that be the aggregate of the repins? In other words,
You mean if your client pins some of
exactly,
your...
they don't have permission to do that. So in other words, let's say they don't have permission to display it yet, or
Right.
they steal my image.
Right.
Then they pin it on
Yeah.
Pinterest.
Well,
Are they then responsible for all the subsequent repins?
you know, that's an interesting question, and I can't say for sure, but I think you got a logical argument there that they would be. However, I would not sit back on your hands and say, oh goody, I've now got a $1 zillion lawsuit because there's been 1,000 repins. I think what you'd have to do is what we in the law call mitigate your damages. So what you'd have to do, you'd have to go to Pinterest and say, pull it down. This is posted without my authorization. I bet Pinterest has a procedure for getting notifications of takedown notifications. And you would also have to ask your erstwhile client to take it down. Before you, now, if Pinterest refuses to take it down and your erstwhile client refuses to take it down, I would say that, especially if it's in violation of your agreement, you got a good shot at arguing that they're responsible for all the logical consequences. The problem is, how do you put a number on that? Is that a $5 violation or a $5 million violation? You know, it's one thing if you get in a car accident. You go to 3 body shops and you get 3 estimates, and you take the average of the 3 estimates, and you pretty much say, here's what the value of the damage is for fixing that bumper. What's the value, what's the provable loss to you of pinnings and repinnings? Hard to calculate in real terms. However, since you brought the subject up, remember I mentioned a couple of times, there are all these real reasons, good reasons for registering your copyright before the infringement takes place. Like if you win, you get your attorney's fees back and you need it to get to court. Another reason to register your copyright before the infringement takes place is you won't necessarily have to prove how much you actually lost, because the Copyright Act says if you can't prove your actual damages to a monetary certainty, the court has the discretion to award up to $150,000. That is a very big hammer in your hand that you can hold over the client who did something wrong. You can say, you know what? I may not be able to prove to a certainty how much you cost me, but I registered the copyright before you did this infringement. It's an infringement. I'm going to go to court and I'm going to ask the judge for $50,000. The judge might award more. Want to settle? And they might have insurance, and they might want to settle. Seen that happen. Register your copyrights early and often. What else can I, Mark just gave me the high sign, so maybe I'll wrap up here. And like I said, I'll be happy to stick around if there's any other questions. Thanks very much. It's really fun.